Hey.
Congratulations to a good week.
Yeah. And I had so much fun binding this. This is the biggest binding that we have, right?
So let's show everybody. This is something we're going to be talking about now. This is the most recent Supreme Court of Canada decision in a case called JJ. And it's
massive.
Yeah, at least a 5 pound, 6 pound decision. And this is a really, landmark decision by the Supreme Court of Canada with respect to the amendments that came out in 2018. We'll talk about it, but these are with respect to sexual assault cases and motions now and with respect to documents or records which are in the possession of accused, and they have to bring a motion to have it vetted by a court and see if it's admissible.
Unprecedented.
And frankly, this decision, the legislation was challenged as to whether it was unconstitutional, and it went all the way up to the Supreme Court of Canada. This is the decision, and this decision is a 6-3 split. So there's 9 members of the Supreme Court of Canada, 6 for the majority, 3 for the minority. And as far as I'm concerned, it created a fundamental shift in evidence in Canada, specifically with respect to sexual assault cases. But this is a monumental shift in evidence.
It almost feels, this case and this decision, like an anniversary for us, because we first met talking about why this legislation was so bad. And then that's kind of how we connected and ended up working together, is because we were both saying, like you said, this is catastrophic, which even though they deemed it constitutional, there's the dissenting decisions and written separately by all 3 dissenting judges. The main one is by Justice Brown. But he starts out, and I just actually want to point out, just for a little vindication for our point of view, so strongly worded.
So just take it so everybody can follow that what Diana's going to refer to now. So when a court writes a decision, you'll have a decision written for the majority, and then a decision, if there's dissenting opinions, for the minority. So you're going to read from the minority. So they're not in the winning section, okay? So there's 3 judges, and you're going to read something extremely important slowly.
Yeah, and it's very strongly worded. So my favorite 2 sentences, very short sentences, right from the beginning of Justice Brown's dissent is, Parliament has legislated a formula for wrongful convictions. Indeed, it has all but guaranteed them. That's how bad this legislation potentially could be if Justice Brown is right. And we found ways to work around it, but essentially it was drafted, and the first 2 paragraphs of the majority decision talk about the need for more convictions, essentially.
I'll read that now, but this is an extremely poignant way to start this podcast. And this may be a bit of a somber podcast for us, because sometimes we're a bit animated and we have fun, but you just read something incredibly important. So this is a justice of the Supreme Court of Canada who opened up their written reasons saying, Parliament has legislated a formula for wrongful convictions. Indeed, it has all but guaranteed them. That is chilling.
And it seems to me to be the goal, to gain convictions at any cost.
And the minority actually wrote this, which I'll just add in at paragraph 198. These appeals arise from a measure that also imposes precisely that risk. The record screening regime enacted under these sections of the Criminal Code represents an unprecedented and unconstitutional erosion by Parliament of the fair trial rights of the presumptively innocent, who, it should be borne in mind, will sometimes be actually innocent.
He's the first one to point that out. There's a presumption of guilt that just sort of permeates the entire majority decision, a presumption of guilt.
It seriously impedes the ability of such persons to prove that innocence by making presumptively inadmissible all private records relating to the complainant that are in the possession of the accused and which the accused intends to adduce in a sexual offense prosecution.
There's a lot of fancy language right there too, but the important part is that they have a specific exemption in the majority section saying this only applies to the same evidence in the hands of the Crown. Fine. Crown does not have to worry about it. It does not apply to the Crown.
Explain that for a second, slowly, so everybody gets this. So it means that privacy rights of an accused
do not exist.
Doesn't matter.
Right.
Explain it slowly so everybody gets this. This is so... I'm trying not to swear. I'm so trying to cut back. It's like I'm in Swear Anonymous. Please explain.
Swearaholics.
Just, yeah.
So it was an interesting point brought up prior to this decision where because the judges in the lower courts were really diverse opinions and so on, but it had been pointed out, well, if the complainant has a privacy right in her text messages, let's just use text messages instead of just records.
And you say she, a complainant can be he.
Yeah.
Right? So, this isn't a
But
he,
if a complainant has a privacy interest in records, so much so that we want to make sure we don't shock and horrify them when they get onto the stand to testify. But the exact same messages, same sequence of messages, if the complainant hands it over to the police, the accused doesn't have a privacy interest, that the complainant can give that over and it can be used any way the Crown sees fit, really.
Correct. So we're talking about communications between an accused and a complainant. And these communications can be by email, by text message, over an app, and which is very common when people are in a relationship or a short dating, whatever. And they will communicate typically by, some electronic means. So the communications, and we'll go into this in more detail, but the Supreme Court actually created more problems by including in the presumptively inadmissible records even messages that are about the actual allegation. So up until now, if it was a communication about that which the complainant has said was a criminal offense, it was admissible. Yes. Now, even if it's about that, it's presumptively inadmissible.
So there's two sections of the code that relate to evidence in charges that have a sexual nature to them that are all enumerated or whatever, right? But generally sexual assault charges, where there's section 276, which specifically deals with evidence of a sexual nature. Used to be prior sexual history, but now it's called anything of a sexual nature, which is, I find, a little bit too broad in terminology. Because, is flirting sexual? It's like, it gets a little bit crazy sometimes. So 276 covered that, and that was supposed to be the most strict part of the code. Then what they brought in is, it's section 278.92 that covers non-sexual evidence as well.
Non-sexual.
Yeah, so these can be mundane communications about, what time does the flight leave? What
time are we getting together for dinner tonight? What time are you coming over to my house? Right?
Yeah, they all have to be vetted now. And you could take, if the complainant gives 3 messages to the Crown, for those in the States, that's the prosecutor, gives those messages over to be used against him, and then we have a sequence that shows that messages were cut out. Now we can't just do that, and that's a pretty big thing, to eliminate certain messages and selectively cherry pick evidence, and then now we have to reveal it all up front.
So what you're saying, which importantly, just to hone in on, is, so these very communications, if a complainant has it on her phone or computer and she decides to turn over some of these messages to the police, which then hands it to the prosecutor, those messages can be used by the prosecution. There is no complaint that can be made by an accused that there's their own privacy interest. Mm-hmm. That doesn't matter. So there's a double standard here. And importantly, often messages are not given out in some sort of comprehensive, coherent fashion. It may be picked from various messages over several days
by the complainant
and turned over to the police. So then it's incumbent upon the defense to say, okay, hold on, that's out of context, but we have to we have to give all our cards over.
And explain the context and explain why it's important to the defense, and
outline your defense.
And the complainant gets to be present and make arguments to try and block your evidence from court.
And so it's important, the minority actually noted, and this is extremely apposite here, it is the only evidentiary rule that mandates pretrial disclosure of defense evidence and strategy before the Crown has made out a case to meet, and even where the evidence sought to be relied on is neither irrelevant nor inherently prejudicial. So that means even evidence that's relevant and not really prejudicial still is fucking barred until you bring this motion. Presumptively barred. Can't do it. Have to bring this motion. Have to reveal your strategy and lay it all out.
And why? Because defense lawyers get demonized. You know, they're even saying it's common for defense lawyers to attack complainant's credibility. Well, I mean, that is a key factor in getting somebody convicted, is that the accuser has to be credible. So, of course, you're going to be going after credibility in a variety of different ways. But they kind of demonize as if all defense lawyers, if not restrained, will do the most dirty-handed, tactics and completely derail the dignity of a complainant to win a case.
So that's a great segue into the majority judgment. So again, majority, minority. So 6 judges of the Supreme Court of Canada ruled that this was constitutional. And they started off their reasoning and the decision as follows. I'm going to read it slowly. It's important for us to absorb this.
Paragraphs 1 and 2, right off the top.
Paragraphs 1 and 2.
Yeah.
If I stumble, please come in, because this is... The criminal trial process can be invasive, humiliating, and degrading for victims of sexual offenses, in part because myths and stereotypes continue to haunt the criminal justice system. Historically, trials provided few, if any, protections for complainants. More often than not, they could expect to have the minutiae of their lives and character unjustifiably scrutinized in an attempt to intimidate and embarrass them, and call their credibility into question, all of which jeopardized the truth-seeking function of the trial. It also undermined the dignity, equality, and privacy of those who had the courage to lay a complaint and undergo the rigors of a public trial. Over the past decades, Parliament has made a number of changes to trial procedure, attempting to balance the accused's right to a fair trial, the complainant's dignity, equality, and privacy, and the public's interest in the search for truth. This effort is ongoing, but statistics and well-documented complainant accounts continue to paint a bleak picture. Most victims of sexual offenses do not report such crimes, and for those that do, only a fraction of reported offenses result in a completed prosecution. More needs to be done.
And I found that so weaselly to call.
Holy f***.
I find that so weaselly to say result in completed prosecutions. What they mean is convictions.
Yeah. Like, we've litigated like a ton of sexual assault cases over the years. They get f***ing completed. Mm-hmm. It's not like they stop because somebody runs away or the court explodes.
Getting a charge withdrawn is so incredibly difficult. They only do it when they can see that the complainant is not going to be credible and it's going to be a waste of court time.
But, here's the fallacy. Criminal trial process can be invasive, humiliating, and degrading for victims of sexual offenses. Well, it's degrading for everybody.
It's degrading for an accused person, too.
Yeah. In part because myths and stereotypes continue to haunt the criminal justice system. With all due respect, we go out of our way. And again, this is not shameless promotion, as one person attacked me on Twitter. This is about how you run a case properly, with dignity and respect.
It doesn't help you to
raise myths. It doesn't. It doesn't ask you to. It doesn't help you to raise or stupid questions,
humiliate and unnecessarily harass complainants.
No,
it just makes you look like a bad person, and it doesn't help the defense at all.
And frankly, if you do that in front of a jury or a good trial judge, you're going to lose.
Mm-hmm.
That's not a tactical advantage. And frankly, that's not my experience with trials. It's certainly not the way we run it. So when they say myths and stereotypes continue to haunt the criminal justice system, this is 2022 with a lot of education to judges and a lot of extremely good lawyers where I'm familiar with in the province of Ontario. Skilled, articulate, capable, have brains, they know how to read law. Mm-hmm. This is not our experience.
And there's regular laws of evidence, too, that already existed.
Judges have, free reign over how the trial runs. If it's going to be of that ilk, then they're going to stop it. Historically, trials provided few, if any, protections for complainants. Often expect to have the minutiae of their lives and character unjustifiably scrutinized to intimidate and embarrass. Dude, that is the past. That's 20, 30 years ago. That's not 2021, 2022, or going into 2023. That is the past that they're speaking to. That ship has sailed.
Yeah. One of the things that always strikes me having,
Sorry, just one other thing. And call their credibility into question.
That's everybody's credibility is...
What's at issue is credibility. Very few often times do you have, a video of what happened. Okay? So it's all a matter of credibility. Yes, we're going to call the credibility into question in defending a case. This isn't bashing female complainants. This is about due process, fair trials, and that we used to have that principle. It's better to let 12 guilty people go free than have one wrongful conviction.
And it must be explained, this is not an agreement to let 12 guilty people go free.
No.
It's a concept. It's a philosophical concept, because a lot of people don't like Blackstone's principle.
Right, it's a good one. But it's not what we want.
I think it means we're agreeing to let, like we're making a numbers deal or something like that.
Right, but no, because the criminal justice system has such incredible power and how it has such an impact on people's lives, we have to ensure that there are strong principles at play to protect against wrongful convictions. That's why that maxim came out. It's not a mathematical equation we live by. It's just the notion, the concept that it's better to have some guilty people go free to ensure that our system is fair and that those that are innocent aren't wrongfully convicted. And we've seen the damage and the danger of that. We're not saying that all complaints that come forward about sexual abuse are false. We're not saying that. We're talking about a justice system based upon the best we can do with human nature and human beings assessing a case.
Mm-hmm. But one of the things that I like to point out too is that you have to think about, for an innocent person who's accused, the humiliation for them that people, first of all, find out that they're being accused of something. Maybe that people find out that they even had sex with somebody, because maybe they didn't really want people to know that they had. But then they also have to talk about their personal private life, and they don't have a choice. They must respond because they're charged. And as hard as it may be to go forward, complainants still have a choice. An accused person does not have a choice. And nobody thinks about how humiliating it is for them to have to get up, and especially because normally their parents will come and be supportive to them. And their parents are going to listen to all these details they have to give out about their sex life. Look, nobody cares about that.
No, and again, this is not us denigrating in any way real and true, genuine allegations of abuse. We are not. For those people who have been truly victimized, they are deserving of the utmost attention by the authorities to investigate and for the prosecutors to mount a prosecution. It just has to meet due process, fairness, and principles that we have and that we hold very dear in a democratic society. That's all we're saying.
And it is difficult to testify if you're a real victim.
It is.
It's not difficult to testify if you're lying about it.
Again, for a complainant to testify about what went on is invasive. It's not pleasant. That said, that's the system we have. There's no other way to do it. We can't ameliorate that type of indignity. It's the process we have. It's the best we have. And frankly, this is a pretty damn good system. And so you can't look to the criminal justice system to be this genteel tea party. It's not. It's not, a confirmatory, stroking system where,
it's an adversarial system. It's specifically
adversarial.
Designed to be adversarial for a very good reason.
So you can't go into it with the blinders that this is going to be, some sort of a cathartic experience. It's going to be a battle. That said, at the end of the day, for whichever side, there may be justice. But there has to be fair principles. And when the Supreme Court of Canada starts off in paragraph 1 and paragraph 2 about the statistics about, the bleak picture of people who come forward, and then most victims of sexual offenses don't report, and for those that do, only a fraction resulted in complete prosecutions, more needs to be done.
more convictions need to happen, is what they're
I'm
saying.
sorry,
That's
this is not what I expect of our court system. This is not what I expect, or we should expect from Supreme Court of Canada, with all due respect. And I have said this a number of times. We have a very bright Supreme Court of Canada. I don't believe any of them want to go out and create wrongful convictions. But by their own doing, they have opened the door now very strongly to wrongful convictions. This is not about fixing a statistic. It's about fairness.
Yeah. Now, we wrote an article as soon as this came out, and which I think summarized things well. There was a point that was made off the beginning. There was some need for guidance if the legislation stands, and it has been in existence since, was it December of 2018?
That's correct, yeah.
And so this is like lots of years going by. Some provinces it was thrown out, so it didn't apply in some provinces. It was so uneven across the whole country. We needed a decision. We needed some guidance. And one of the things, as I was reading through this, paragraph after paragraph after paragraph, I was throwing my glasses on the table. I was like throwing things around the room. I was getting so frustrated because they kept on saying they were going to give guidance, and then they used what I would call weasel words, saying, well, this wouldn't necessarily apply to everything. And it's just like, so here's our guidance. These things will likely be true. It's like, likely? That is not helpful. It still leaves it open. And then, of course, they use the word contextual.
Yeah, so you're referring to something great. So there's a number of records. So that means documents or communications in the possession of the accused. Well, this was a whole dispute.
What is a record?
There's one that we all understand. Medical, therapy, and employment information. We understand that. But a record for other purposes, Supreme Court said, it's based on content and context, not only the platform of the information, such as a text or audio recording. So there really is no guidance as to what they mean. And in fact, this is where we started off in saying, I find this very hard, but, they said 278.1, which is one of the section of the criminal code that's relevant.
Defines what a record is.
Defines a record. So where privacy is engaged, namely the provision concerns only records that could cause potential prejudice to the complainant's personal dignity. These factors suggest that the scheme is not intended to catch more mundane information. Moreover, given the accused's right to make full answer defense, mere discomfort associated with lesser intrusions will generally be tolerated. It doesn't help us. In the context, the complainant's privacy in open court will be at serious risk only where the sensitivity of the information strikes at the subject's more intimate self. Sherman Estate at paragraph 74.
I know, just such a bizarre case.
Sadly, the Sherman investigation into that homicide, that really doesn't help anybody. This is really a throwaway that doesn't help give guidance.
And and again, privacy is so subjective. So anybody can claim that they feel their privacy is violated. And as we see, violence is all kinds of things nowadays. Just like, somebody using a word that triggers you in some way is some sort of a violent form of violence. So again, we're still lost as to what is it that's going to strike at your dignity. It's just not helpful.
Will be at serious risk only where the sensitivity of the information strikes at the subject's more intimate self. What does that mean?
Okay, here's another thing that got me. They're saying, okay, it should be fairly clear. It's got to be a record with it's the content that matters, not whether, so it's not automatically a record because it happens to be a text message between the accused and the complainant or whatever. It depends on the content. But then they actually say in the end, after they go through this whole thing about guidance, they go, in the end, the accused is in possession of the evidence. They know what it is. They know the context of it, so they should be able to figure it out. But if you're wrong,
you're in trouble.
If you
Judge
think there's no way,
shut you down. You can have a mistrial. Your client
and
can
ultimately,
get convicted. So
based on
let me
other
just break this
decisions,
down for a second. So the Supreme Court of Canada said, lawyers who are in possession of these records should be able to determine, based upon this decision and other decisions,
you don't need a judge. You can figure it out.
What's a record? And we used to have something called motion for direction. So if we weren't sure, we could bring a motion and disclose the information and try and determine, is this something which is captured by the section? Based upon this decision, we abandoned a motion for directions and said, it. I'm not going to make this decision because, beauty's in the eye of the beholder.
Well, the purpose is that you could actually seal the stuff and the complainant can't have standing, right? So you could actually find out if you even need to go through the whole process where the complainant can then argue against you and get provided a lawyer to do so and all this other stuff. So if it's not a record, you can find out first. then what they did is they said the complainant might actually get standing at a motion for directions to find out if you need to do an application where they don't have standing.
Yeah. So for those who are not familiar with what we're talking about is, when you bring a motion to a court to say help, motion for directions, help, here's the documents. Are these actually a record that engages these core privacy rights of the complainant, or is this something that's not engaged that way? And the complainant doesn't get standing. They're not a participant in that proceeding. That's all by the side now, because in their reasoning they said, well, at a motion for directions, maybe a complainant could have standing because these issues are engaged. It just made the whole process unworkable.
We don't think you should be using court time to do this.
Right.
If you can't figure it out, then bring your application.
Right. So really, in essence, what it did was it said to us, who's very familiar with these cases, is to say, forget it. A motion for directions is a waste of money for our clients. It's a waste of time. Just bring the motion. We have no choice but to disclose. Period. We just got to do it. Done. But I wanted to say again, when we opened up, we said the Supreme Court expanded, in this case, what a record is. So let's just imagine, hypothetically, for a complaint, and you have to think about this, and then I want
Nobody
you to
was
comment.
even disputing this. They did this on their own. I didn't even think this was I think the Crown was actually thinking subject matter of the charge. Like, this is what you're going to get into.
Right. So what you're saying is what the Supreme Court of Canada did on this one point, we don't think anybody was really arguing. But so let's say the allegation is somebody has been dating for about 2 months. They went out on a date. They had intimate relations that night. The complainant thought she was sexually assaulted, but they have communications afterward. And the communications say, I had a great night. Dinner was wonderful. I loved our time together. You were so hot in bed. Oh, thank you so much. You were wonderful. I really loved being with you. And there's this exchange, but then afterward comes this complaint saying that I was sexually assaulted. And that is the communications are about that particular date, that particular night, that particular sexual encounter for which the complainant,
which is called the subject matter of the charge, says was a sexual assault. It used to be up until this decision that when you could pinpoint it directly to the allegation, that is not captured by this section of the Criminal what's
Code.
Supposed to be the strongest section, most protective section, 276, that covers sexual history and so on. It was like, so that's the thing that was supposed to be the most strictly governed evidence, and it was immune. It was not captured by, and it still isn't captured by 276.
Right. But the Supreme Court of Canada has now said it's a record. So if you have messages about the complaint, like about the sex that you had, saying, it was wonderful, I consented, it was great, you can no longer hold that back and cross-examine on it. That has to be disclosed. And you got to think about that for a second. That's an extraordinary move by the Supreme Court of Canada.
So this is a recent decision, and actually just in terms of that section.
Yeah, so this is a really good example of how this point now can be manipulated in other cases. Take the lead. This is really good.
So this case, and this is actually considered to be Canada's big Me Too case. This is McKnight, and he was essentially Canada's Weinstein. He was working in the bar industry, and he had like over 20 complainants or whatever. It was the first really big Canadian case. And
this is in Alberta.
So, I've got a bunch of other stuff in here that's really interesting, because this is one of the first cases to cite this decision, JJ, and talk about. So the question is this going to be helpful for guidance for the courts of appeal and for the lower courts and so on? But they mentioned in this, in the recent decision of JJ, speaking on the topic of, and the section of JJ is called Records of a Sexual Nature Not Covered by Section 276.
Right.
And then they quote what the Supreme Court has to say about that. And I had come across, because I was tracking every decision on these applications in terms of what was going to be allowed into court and what wasn't after the legislation passed. And I remember telling you, oh my God, there's a case where a video, it's a short video, but there's a video of the complainant in the backseat of a car that is actually the moment she says she's being sexually assaulted. And the judge says, well, it would be allowed under 276, but I think under 278.92, that it doesn't really tell us a lot about what was going on. You can't really see if she's drunk or sober or whatever. So she actually didn't allow them to use a video. Like you were saying, you usually don't have videos. They had video. They weren't allowed to use it in court.
So what's the import of this case? Explain it carefully for everybody to get, because it's important.
Yeah. So
and people watch from other jurisdictions. So we get comments and on Twitter, questions asked from the United States, from the UK, and from other jurisdictions. So I think it's important for other lawyers who are watching or other people from other jurisdictions to understand what bullshit is happening here.
And it's not just confusing because it's law or because there's fancy language being used. It's literally confusing. Like we can see from all of the judges who disagreed on how to interpret things that this is confusing as well for people, members of the legal system.
Absolutely. So just reiterate, what's the import of this decision relying upon that aspect of this case?
What they're talking about in here, and I don't know, there's some indication it might be appealed, so we might get Supreme Court to weigh in on whether or not they're interpreted properly. But what they started talking about is, again, what is subject matter of the charge, and does it include proximate sexual activity? And so this has been an issue too. Is like, so if you go, in your example, you've been dating each other for a couple of months, you go back, you get into the house, you kiss, you might make out on the couch for a little bit, then you hold each other's hand and go to the bedroom. Does the sexual activity of the charge start when the bedroom door closes, or does it include the kissing? Is that sexual activity?
Very good point.
Yeah.
Look at how artificial this is. So the kissing and holding hands or touching in a living room prior to going to a bedroom is interpreted, frankly, in my opinion, as prior sexual activity. And may not be relevant.
It quite often is. You have to assume, as a defense lawyer going in, you have to assume that it will be interpreted that way. Because if you're wrong and then you get there, you're not going to be able to talk about it.
And that relates to, so that one would think it's all part of the general flowing of the evening, the subject matter of the allegation. So if there's this intimate contact that's truly consensual and ongoing, that would be subject matter of the charge. No, it's parsed out and can be excluded in some insane world.
So the Crown in the McKnight case, on appeal, not at trial, but on appeal, they conceded a couple of things, saying that they now accept that sexual activity other than the specific act alleged to constitute an assault may form part of the subject matter of the charge, right? Because previously they had taken the position that only non-consensual activity was subject matter of the charge. So
right.
Anything consensual, even if, in the middle of a sexual assault, a person says, but then I had a really nice kissing moment with them, you wouldn't be able to talk about that because that was consensual, right? I mean, I don't even know. It was like, and there's some great quotes from judges saying how you can't parse things out because it gets ridiculous at a certain point. But the Crown had conceded, they gave an example, agreeing that a subject matter of the charge, notwithstanding an allegation of assault, could include something like kissing in the living room and then walking hand in hand to the bedroom where they proceed to where the accused is giving evidence, proceed to consensual sex. So it would be practical and sensible to treat that entire interaction as a single episode of sexual activity. The Court of Appeal in Alberta disagreed with the Crown on that.
Do you get that? Like, this is so subtle. This is a very sort of academic drill down on this, but this is so important as a basis of law in Canada, a fundamental shift in evidence law here, and this will impact other jurisdictions. So the Crown thought it was part of one flow of information as to how the evening progressed, as we call in the business one transaction. The Court of Appeal said, no. What happens in the kitchen or what happens in the living room prior to going to bedroom are all prior sexual acts, and you have to try and bring emotion to see how it's relevant. That means we are sanitizing, we are artificially breaking up what is human interaction, and we are eliminating from it truth. They talk about the truth-seeking process. Give me a break. This eliminates relevant information that leads to the truth-seeking process. This is bullshit. Yeah. It's absolute bullshit. And I'm sorry to say that because, again, I have good regard for our Supreme Court of Canada, but I'm frankly shocked at this.
It just didn't give guidance, and
not just, but this is just it's.
But so they talk about how it's been like
sad.
Controversial, whatever. They quote various number of decisions, saying at some point, quoting another judge, saying at some point parsing out each moment in a sequence of events and defining it as a separate activity becomes ridiculous. So they're quoting this, saying, we're aware that some judges have felt this way, and that courts have noted distinction between past sexual activity and the sexual activity that forms the subject matter of the charge can be difficult to parse. And the reasons they give for not agreeing with the Crown Counsel then they say, in our respectful opinion, it's too vague and open-ended to provide workable guidance to trial judges. And then to give that guidance better, they start citing JJ. And JJ, as we said before, doesn't actually give them any guidance at all.
No, so they're referring to it where we don't have the guidance. So we're in a flux again.
It's just a big circle.
So I don't know if we're running long on this, but we'll wrap up. But let's say a couple of good things about this decision. But I think the import of what people have to understand, I'm sorry this has been a bit dry, but this is a fundamental shift in evidence law in Canada. And it is a fundamental shift where, as the minority had said very clearly, and I absolutely agree, it is the only evidentiary rule that mandates pretrial disclosure of defense evidence and strategy before the Crown has made out a case to meet. And even where the evidence sought to be relied on is neither irrelevant nor inherently prejudicial. This is a major, major, major blow to fairness, and it is a significant support for wrongful convictions.
And you don't have that type of burden or blocking of your defense strategy if you murder somebody, only if you have some sort of sexual charge.
Right. So what they were saying is this does not apply in any other trial, whether it's for homicide, fraud, or whatever. I will say this.
Case to meet, though, I want you to explain what that means, because that is actually, I forgot to mention it when you read that earlier.
Yeah, good point.
Case to meet, I think people need to understand.
Do it in normal terms, because I'm
because I had to learn what exactly this meant, and because it was a big part of the constitutional challenge. So it involves your right to silence and your right to not even have to call a defense, right? The very first thing that happens...
Who has the burden?
The prosecutor always has the burden, and before the defense calls any evidence at all, the Crown has to call all their evidence.
Right.
And then you can, at the end, the Crown has to call all their witnesses, put in all the evidence that they think they have to show that they've met a burden of proof.
Correct.
And at the end of the Crown's case, they then close their case before defense says anything.
Right.
And at that point, the defense can actually say there's no case to meet.
Well, really astute. That's great. So, the presumption of innocence and proof beyond a reasonable doubt are two core principles in every common law system. The Crown or the prosecution bears the onus to prove their case. So they have to mount their case before a defense has to be called. We, in sexual assault cases in Canada, have to disclose these records.
With an affidavit.
With an affidavit from our client, disclosing our strategy well ahead of time, including your defense, in order to see if it's admissible. So that
in detail explaining the relevance of all the evidence to your defense strategy.
That is something you have to do well before the Crown has ever opened their mouths or called a witness. Now, I will say one good thing. The Supreme Court of Canada did say this. So there's two stages to this process. So stage one, we file the application and all our material. They did say that on stage one, the complainant and their lawyer does not have standing. So our materials will only go to the Crown. It can be prevented from going to the complainant and their lawyer. And then a judge at stage one can decide if any or how much of the defense application should be turned over to a complainant and a lawyer. And it could just be a summary. So that's a bit of a safety valve to prevent, so we have to be fair, to prevent an accused to tailoring their evidence or tailoring the argument.
The complainant
tailoring their evidence to what the accused has put forward. That said, it's kind of cold comfort because it's already out there, and the majority of applications that you bring, and we've done a lot of these since this legislation, it's almost inevitable it has to go to stage two, and it's almost inevitable based upon the law and the legislation that they're going to have some say in it and need some disclosure. So it's there as a bit of a safety valve. I don't think it really means much.
I think they did have some strong wording in there too about like you read out earlier, just being uncomfortable with people hearing this stuff is not enough to make it, a privacy issue.
Right.
So there is some good stuff that I think we can work with, and also we've been very successful. I'm not concerned because our applications have gone really well.
Yeah.
I'm not concerned with the stuff we're doing through here. I'm concerned because of my nonprofit and the number of people who contact me who couldn't afford lawyer, had legal aid, all this other stuff. They're not prepared to handle this stuff. And so those are the cases where I'm thinking like these are where the wrongful convictions are going to happen.
Yeah. So you got to, as I think we should close up this segment, but or this podcast, but that's a great point. So it's an access to justice issue, right? So you got to think about this in some terms, and I think you got to talk about this a little bit as we close out. But just imagine you're accused of this offense and you got to hire a lawyer. This is expensive. This is time consuming. These applications take a lot of time because clients will often give us, not 2 messages, but hundreds of messages.
Thousands of pages.
Sometimes thousands of pages where your eyeballs are popping out reading it, right? Mm-hmm. And you got to figure this out. And then,
except I'm OCD, so.
Yeah, thank God. But not just put it into, a package for your application, but assess it, analyze it, and argue it out in written documents so that you have this ability to marshal the defense and get it to be admissible.
Making all your defense strategy decisions before you've even heard what they're going to say in court.
You're basically running the trial. You're basically going through all the trial arguments and strategy and everything to make sure you got it right for the motion. You're doing it twice.
You can only make assumptions about what's going to be said in court based on what was said in the police statements and so on. Like you don't actually know.
So it's an access to justice issue. Can you imagine, sadly, those who cannot afford, poor legal aid lawyers.
There's a 75-year-old that I spoke to who's self-representing because he can't qualify for legal aid.
Right, and so let's just say this. There's nothing wrong. We accept legal aid certificates, but it's so chronically underfunded. I want to be,
and the complainant gets a free lawyer, and an accused person can't get.
I want to be sensitive about this, but we know the provincial government has a lot of issues with respect to funding of everything. We've got problems with healthcare. We need more nurses. We need more doctors. We need more in our healthcare system. We need more for education. Then it comes to our criminal justice system, which is chronically underfunded. Legal aid is a very important mechanism for those who do not have resources to hire a lawyer privately and pay an hourly rate. And that is chronically underfunded, where lawyers are not paid anywhere close.
It's at a crisis level.
They're not paid anywhere near the amount of hours necessary to do this. This is a trial in and of itself. So there's a chronic underfunding. And I have posted on Twitter what's going on in the UK. There have been cutbacks in the UK such that criminal lawyers are exiting the criminal bar. Goodbye. See you later. I can't make a living.
Mm-hmm. Well, I got a little point we could make to close this up. If they want to get more convictions, which is what it looks like they're looking for, they could just cut off legal aid completely.
Well, they may be doing that.
I just want them to be honest. If they don't care about wrongful convictions, just say it. I just want them to be honest.
Yeah, I tried that once when I was in the Court of Appeal.
If you enjoy this podcast, like, subscribe, hit notifications, and if you're listening to it on Apple, I think there's some sort of a comment thing you can do.
And you know what? Thank you. Keep sending your comments because we're getting a lot of great comments and questions.
And suggestions for
it's really helpful, and thank you very much for that. Until next time. Cheers. Oh, what? I just want to thank my client who continually funds us with these wonderful Macallans. So God bless you. I can't name him. He's a client. He's innocent. He'll be proven innocent, but he is such a gem. Thank you so much.
Yes. With
See you later,
taste.
guys.
Good taste in scotch.
Thank you.